Now, we'll talk about power of attorney, as we just mentioned briefly. So a power of attorney is something that any of us can do at any time. And what that does is it gives some individual who is called your attorney, assuming you have the document properly prepared, the right to make financial decisions on your behalf and to sign financial documents on your behalf. That it can be very limited, it can be very, very wide. So if, for instance, one thing we see in our world, in my practice, is that somebody will sign a power of attorney authorizing me or some other person to sign a deed when they're selling their house if they happen to be out of town or out of the country. Of course, in Newfoundland now, many people are buying and selling property who are from Europe and America and all over the place, so it's easier to have somebody here who can sign on their behalf. However, people also will give a wider power of attorney, which will say you can sign checks on behalf of an individual, you can sign deeds, you can open bank accounts, close bank accounts, pay bills, and all that kind of thing, and that more commonly is the kind of power of attorney we see. However, the person has to have capacity to A, to sign the power of attorney, and B, if it's an ordinary power of attorney, then on the date that they no longer are competent or don't have that capacity to make their own decisions, that power of attorney ceases and has no force and effect. So there's a special kind of power of attorney that is permitted by our law called the enduring power of attorney, and that was created by the Enduring Power of Attorneys Act. And that's something that is sometimes here referred to as a living will, because what it means is that while a person doesn't have capacity, then somebody else is entitled until they die to make whatever financial decisions are provided for in that power of attorney document. And again, commonly, these are very, very broad powers. So, and realistically, and so they should be. Now, it's important that you have somebody you can trust for that. So, you want to make sure that since you're not going to be, the person who's made the power of attorney is not going to be there to supervise, that it's somebody that you believe is going to have your best interests at heart, the best interests of your family at heart, and that's a decision that really only the person making the power of attorney, the enduring power of attorney, can make. So it's important to assess if that's the person who has the ability, I guess from a financial point of view, and it was a trustworthiness to not do things with this person's, all their financial assets that might not be in the best interest of that individual. You don't want somebody who's going to go and frivolously invest it or frivolously spend it on things that really are not appropriate. So trust is a very, very important thing. In order to have an enduring power of attorney, there are some requirements, and they're set out in the Enduring Powers of Attorney Act, as I have mentioned. Firstly, it's got to say in it that it is an enduring power of attorney and that it applies during the legal incapacity of the person called a donor who's giving the enduring power of attorney. And it's got to be signed by the donor, and it's got to be witnessed. And it's got to be witnessed by somebody really who is not a child of that individual or the spouse of the individual. It really should be somebody who is altogether different, just to provide that degree of independence. As I said previously, in terms of what an attorney can do, it can be very little or a lot. Typically, for an enduring power of attorney, it is a lot. And that means that they can do anything in relation to the finances of the person who's granted the power of attorney that person can do themselves. And that means that if the person is incapacitated for 20 years before they die, then that person may have complete control over paying the rent and paying the bills and making sure property is maintained, sold, investments are made, and these sort of things. So the power is wide, and for larger estates, and sometimes there are very large estates out there, it's a great deal of responsibility. And that person, of course, does have a duty to act in a way that best protects the interests of the person. However, it's again a question of trust. It's one thing to say you have a duty, but it's much more important in my experience that you have somebody you can trust to do that duty. Because the mere fact that somebody has a duty doesn't necessarily mean they're not going to abuse that. So trust is a vitally important thing, and that's not a legal thing, that's just a practical thing in all of our lives, that we need to assess who is best, who is close to you, and best equipped to do the things you would want them to do and make the judgments you would want them to make. So that's something you should be concerned about. And that's probably almost the most important document that somebody who is developing the signs of Alzheimer's or other dementia can do. And again, this is part of this ongoing assessment of when it is that somebody is still able to do something, even though they are showing signs of deterioration. So the fact, for instance, this is one little thing you might want to be aware of, the fact that somebody is losing a memory of things doesn't mean that they don't have capacity. Now, clearly, if they don't remember what they have, or they don't remember who's around them, then that's a whole other thing. But if it's simply a question that they don't remember something they said to you, a day ago or 2 days ago, doesn't mean they don't have capacity. It's a sliding scale, and it depends on the judgment of both medical and legal professionals who are involved in this. And any of you who are involved with families who have a person who is suffering from that kind of disease will probably have your own views and probably as good experience as any legal or medical professional. So it may be wise in your own mind, for your own purposes, to make your own notes and give your own input to the people who are drafting the documents and considering drafting documents as to whether they have that capacity. Because again, you run into situations where if there's something that goes wrong down the road that somebody disagrees with, you may end up in a legal fight over whether there was in fact that capacity. So that kind of evidence is important, and quite frankly, the earlier the better in this journey. You can get the paperwork in place, whether it's a will or an enduring power of attorney for an advanced healthcare directive, which I'm about to talk about, the better it will be and the more sustainable and effective it is likely to be found to be if there's any challenge raised.
Mr. Wicks, could an attorney have power of attorney? Like, would a lawyer have a power of attorney?
Only if the lawyer is granted that. So,
okay, so
to be an attorney is not to be a lawyer. An attorney is simply a phrase for this purpose of somebody who has the power to sign documents in your name. That's what it is. But it could be a lawyer. I have been a power of attorney for others over time. And it could be an accountant. Accountants commonly will be called on to do that. And it could be a family member. It really depends on the range of your acquaintances and who you trust.
It's usually a family member.
Almost always a family
yeah.
member. But I have been myself from time to time in my capacity as a lawyer, but usually for more limited purposes.
I suppose if people are widowed or don't have other family members around and things like that is when you would usually see yourself or an accountant, maybe.
I think it's true, but here's a situation. What if you have somebody who's a widower or a widower, and they have youngish children, young adults perhaps, who don't have a lot of experience in life, or who might not be settled in a way that they have the life's experience that would assist them in making decisions, or might have their own financial needs that might create some concern about what they might do with the money, even though they're allowed to do it. So, if you don't have somebody in your family you can trust, then certainly I think you're right, that it's probably best to look at a professional. And in fact, there are actually trust companies out there who provide that professional service for you for a fee if you choose to use it. Again, almost always in the case of larger estates, whether the estate of the person who has died or the estate of the person who is not able to make their own decisions. And those fees will range from 1 to 5% of the value of the estate. So that's the kind of money we're looking at. But again, unless it's a substantial estate, it's rarely the kind of thing that would be done. Now, we'll talk a little bit about advanced healthcare directives, and this is a relatively new innovation in the law in Newfoundland. There isn't this legislation in place in every province in Canada. And what it effectively does is it allows an individual to say, look, there's going to come a point in time when I'm not able to make my own decisions for medical reasons. And those medical reasons are going to be that I'm going to be in a serious medical condition whereby I'm in a hospital and somebody's going to have to decide how aggressive the treatment I'm going to get for my particular condition is. And in a practical way, and many of you have already been through this, you will know that the family members who are considered the next of kin are usually relied upon by the doctors and nurses to make what can be end-of-life decisions or treatment decisions. And these are all very important things, but the person who's being treated, the person whose life is coming close to ending, doesn't get to say in that. And sometimes, again, in family situations, you can get disagreement between individuals in the family as to who is going to make that decision, whether they're going to say, look, yes, there will be aggressive treatment, or there won't be aggressive treatment, or we are going to turn off the ventilator, or we are not. And that puts the hospital staff and the doctors in a very difficult situation, and the family, of course. So the purpose of an advanced healthcare directive is to put on paper in a legally enforceable way what the wishes are of that individual. So that if you do an advanced healthcare directive under the act that permits that to be done, then you can firstly give instructions to what you want to be done, how aggressive you want treatment to be in particular circumstances, and perhaps even more importantly, who your decision maker is going to be in your absence. So it might not be all of your children, it might not be your wife, it might not be your mother, father, husband, whatever it happens to be. It might be a particular person that you trust and you may have shared your wishes with, or who may share the same principles that you have shared during your life. So again, it's an important thing, and it can avoid a lot of controversy when that difficult day comes along. Now, it's only effective legally while you're not competent. So anybody who perhaps has been sick and has been on various kind of medication or in some kind of unconscious state might recover. Now, somebody perhaps who is in a dementia state might not recover, so it may not be as important an issue in terms of being competent or incompetent in that latter situation. But the reality is that if for whatever reason you recover competence, then the advanced healthcare directive no longer applies, and you have the ability to make your own decisions about your health, which is really as it should be. If you don't have that competency or that capacity, then that substitute decision maker is going to have that power on your behalf. Now, you've got to be 16 to make an advanced healthcare directive. It's got to be in writing. It's got to be signed by both you and the decision maker and 2 independent witnesses. So again, this is a technical thing because of the importance of the authority being given to that individual about somebody's life, which is what it's all about, and that's got to be properly done. And again, unless it's properly done, then that will not be effective. So commonly now in legal practice, when people come in to make a will, they are often doing not only a will, but also an enduring power of attorney and an advanced healthcare directive all at the same time, so that those things are all dealt with while that decision or that analysis is being made as to whether the person is competent, and then it's done. That's not to say you can't change it, at least while you're competent, but at least it's done at the same time. And I certainly encourage people to consider doing an advanced healthcare directive in anticipation of something going wrong with health as time goes on. Now, I've mentioned as well, in terms of what goes into an advanced healthcare directive, the substitute decision maker. And it is important to make sure that the substitute decision maker as well is aware of whatever instructions you've given. So, the substitute decision maker, quite frankly, has got to sign off on this thing. You should probably have a copy of your advanced healthcare directive as well, on a practical basis, because again, you come down to this problem of, well, where is it? And who can find it when the call comes at 3 o'clock in the morning from the hospital? And if the substitute decision maker, who's likely a close family member, is there and has a copy of it, then that will relieve a lot of pressure and stress. Now, the other thing you can do is you can name substitute decision makers. So you might name that document if John Smith is not able or willing or available to act, then somebody else can act in their stead. And this is an important one too, that if you don't want somebody to be a substitute decision maker, you might want to say that, because that may be somebody perhaps who's close to you who would ordinarily be looked upon to give some kind of direction at the end of life kind of point. but you are in disagreement with me as to how aggressive treatment should be, then you may not want that person having a role. You can say that without the directive. I can say that I've never seen that happen, but it's something you can do under the law.